My name is Joseph McDaniel, and I'm a bankruptcy attorney, and since 2005, I also get to tell you that I'm a debt relief agency, and I help people and businesses file bankruptcy. Today's bankruptcy topic is, how will I pay for a bankruptcy if I'm broke? How much will my Chapter 7 bankruptcy cost? There's an old joke. A bankruptcy attorney walks into a cocktail party, and the divorce attorney asks, how does a bankruptcy lawyer get paid? To which the response is, up front. There's a certain amount of truth buried in that joke. A consumer bankruptcy attorney doesn't want fees owed to him to be discharged along with all the other debt. So that attorney has a tendency to get paid in full prior to the filing. For that matter, a commercial bankruptcy lawyer has a similar concern, so he may want a $10 million retainer. Some bankruptcy attorneys take tiny payments over a long period of time. I don't, because invariably in my experience, when I take a tiny payment stream from a potential client, something terrible happens, like a lawsuit, a garnishment, getting fired, or a foreclosure. And that happens long before their fee is paid. And they know I'm not exactly their lawyer yet, and I know I'm not exactly their lawyer yet, and yet both of us are unhappy and confused about our status. So instead, I take retainers from my clients because, as Abraham Lincoln said, that's how a client knows he has a lawyer, and a lawyer knows he has a client. And the written retainer agreement is just as important because it sets out exactly the scope of what I've agreed to do. If I have to jump in front of a bus for a bankruptcy client, that costs extra, as it's set out in the retainer agreement. And yeah, sometimes I'll take 2 payments or 3 payments, because I understand that it's sometimes not easy to find the dough all in one lump. The one area I can't help with is finding the money for the retainer. I can make a lot of debt go away and help the debtor keep most or all of the stuff. I can't do that trick with the loaves and the fishes. Now, the client can beg or borrow the money from mom. That's fine, although if the client borrows it from mom, mom is then a creditor and must be listed on the schedules and also as the source of the dough on the 2016B bankruptcy fee disclosure statement. And mom will be discharged along with the other creditors, but that's fine because daughter or sonny boy can pay back dough to loving parent post-filing. Or the kids can get a gift, not a loan, from the parents, at which point they don't need to list mom as a creditor. Although if they get a gift, that will count as income on the means test. So I generally prefer it if the dough for the retainer is a loan from parents or friends, even if that means they have to be listed as creditors. Or the client may sell a non-exempt asset, the third automobile, for instance, for fair market value. Selling a non-exempt asset or for that matter, an exempt asset, to find money to hire a bankruptcy lawyer is fine, although that sale, which is a transfer, must show up somewhere in the statement of affairs, and the proceeds must be accounted for just like any other pre-petition transfer, and the amount paid to the lawyer must be reasonable, as reasonable is defined in that jurisdiction. There is substantial geographic differential in that area. Or a potential client can pull money out of a retirement vehicle to pay bankruptcy counsel. That might well have a tax consequence as well as a means test consequence. Speaking of taxes, a client will sometimes wait for a tax refund and use that to pay the bankruptcy lawyer, since a tax refund will go to the bankruptcy trustee if it arrives after the filing. That makes a certain amount of sense. For that matter, once a potential client makes a final determination that they will be filing, they probably won't want to keep paying on their credit cards because that's a lot like throwing money out the window if they know that they'll actually be filing. Obviously, it's a bad idea to stop paying on debts relating to a car or a house that you want to keep, at least in most cases. But the money that was being spent on credit card payments can be used to accumulate a retainer for a bankruptcy filing. Ditto with mortgage payments if you're not going to keep the house. Some people think they can use a credit card to pay a bankruptcy lawyer. I don't feel real comfortable with that because credit card use within 90 days of filing is presumptively non-dischargeable, and it just seems wrong. Over the years, I have sometimes suspected that some clients have used credit cards to pay other expenses, which frees up money to pay a bankruptcy lawyer, and then they haven't filed for 120 days after they used the credit cards. But there are only 29 hours a day and 12 days a week, and I can only suspect some things. On the other hand, if mom wants to take a cash advance and pay for daughter's bankruptcy, that's perfectly okay. Mom will remain liable for the debt and presumably pays that debt, so there's no bad deed done as to the credit card company. If a potential client makes it into my office and can't possibly afford me, and has no assets to speak of, and no relatives or friends from whom they can borrow money for a bankruptcy filing, and no particular complications that show up in our discussions, and has very, very modest debt in the range of $4,000 or $5,000 or $10,000, I might refer the potential client to the Self-Help Center at the United States Bankruptcy Court. On the other hand, because there are different volunteers there from time to time, results may differ, kind of like a barber college. The presumptively reasonable fee charged by an attorney for an uncontested Chapter 7 bankruptcy in the District of Arizona the last time I checked was around $3,500, and some lawyers will charge as little as $999 plus costs for a small uncontested consumer Chapter 7, although they may very well charge for add-ons. Read any retainer agreement very carefully. A document preparation operation, sometimes called a docu-prep, will typically charge around $200 to type your bankruptcy schedules and forms and lists. Such a business is prohibited from providing legal advice, so the utility there is somewhat limited. And sometimes the advice that they give is incorrect, even if they're prohibited from giving advice. Now, if there's a business involved in a bankruptcy filing, or the debt involved is greater than $1 million, I personally may charge more than $3,500, depending on the case and the amount of work I can see coming in the case. And if the name of the business was Ponzi Schemes R Us, I'll always charge a good deal more. I also tend to charge more to file a bankruptcy for a professional like a medical doctor, because those cases get huge amounts of scrutiny from the trustee, and they always involve a Rule 2004 examination. Note that the filing fee of $299 for the court is extra, and the client normally pays for their own pre- and post-mandatory credit counseling. Heidi, my paralegal, keeps me up to date on which of those approved, online, mandatory counseling services seems least expensive. I know for certain that brand new lawyers who have never filed a Chapter 7 bankruptcy for a client before will be happy to file for much, much less. And lawyers who have just gone to work for a giant, heavy advertising bankruptcy mill will take your case for whatever dollar amount their bosses tell them to take, which is normally fairly high, because they have a lot of television advertising, and that's very expensive. There are also instant bankruptcy experts who recently transmogrified away from divorce practice or personal injury practice and are now instant experts in bankruptcy. And some of them are very nice people. I personally set my fees after I visit with a potential client because I want to know the person or the couple I'm representing. And I think it's very important that a client have an opportunity to meet with me prior to making any retention decision, because if they can't stand me, or if I can't stand them, they really need some other counsel for the 1 to 4 years that the case will take. And I set my fees on a case-by-case basis, and my fees are comparable to other lawyers in Phoenix with comparable experience, credentials, and ratings. Note that Chapter 13 cases are more expensive than Chapter 7 cases, but since the debtor is trapped for a minimum of 3 years in a payment plan, the legal fees in a Chapter 13 bankruptcy should be the least of their worries. A Chapter 13 is very, very expensive when payments over the life of the plan are calculated, and I prefer, if at all possible, to find a way for a client to file a Chapter 7 if I can. Thank you very much.